excited as well. Abdullah, ready to one.
Welcome to Dr. TSPR show. This is Dr. Tangella Shiva Prasad Reddy alias Dr. TSPR. Namaste, Adab, hello and a warm welcome to our esteemed guest of today, B.V.ACHARYA ji. Namaskar sir. Swagatam. A warm welcome to you. At this age, B.V.ACHARYA ji is a senior advocate and 5 times Advocate General of Karnataka, and you should not forget the former Chief Minister's case was also in his repertoire of professional achievements. He has got many credits, professional credits. I'm not going to read everything now, but he has received awards at the state level and at the Pan India level too for his contribution towards the legal profession. And even today, if you remember right, when high courts were not trying to discharge their due duties, their inherited strength in regards to personal liberty, it was again B.V.ACHARYA ji. He said, Dr. Reddy, are you ready? Let us go for the live show. He said he reminded high courts of their inherent strengths, of their inherent power to come to the rescue of citizens in the form of personal liberty. And even he questioned Supreme Court's intervention into day-to-day affairs. That means the rights have to be protected if the governments or the authorities, if they try to subdue at the cost of the public suffering or citizen suffering. That is when he was reminding the high courts, come on, do your duty. Personal liberty, come whatever may, should not be hijacked by anyone. In that pursuit, even that time when our boss, Goswami of a news channel, when he was arrested abruptly because of questioning the governments. Journalists are there for the freedom of expression, and it is nothing but the freedom of speech. It is free press, and when it is curtailed, when it is suppressed, the voice of the people and the people participatory constitutional democracy will be in question. Then Goswami and of late Mr. Zubair, another journalist, was picked up, and believe me, every time similar sections, numerous police stations, they were booking the cases. They were not allowing him his right to bail. This is what was brought out by B.V.ACHARYA ji on that famous case of Mr. Goswami. He said it is right to bail is also a fundamental right. Now, because of the prevailing situation which is existing across India, he said, let us go and try to read the constitution in public favor, for public understanding in regards to what is arrest, what is detention, and what is bail. And such an important topic of today, because it is infringement of the fundamental rights. Why it's happening? Because of lack of awareness amongst the citizens. Citizens forgetting that they themselves are the constitution, having submitted constitutions to themselves. So welcome sir, B.V.ACHARYA ji. Yes sir.
My dear friends, the topic of talk today is arrest, detention, and bail. Now, personal liberty is a most cherished human right. It is even our constitution has given great importance to personal liberty of an individual. Article 21 and 22, as also Article 20, deal with personal liberty. Now, for a person of reputation if there is any ill fame, it is worse than death. That is what Bhagavad Gita says, and which has been reproduced in one of the judgments of the Supreme Court also, which says that reputation is a very valuable thing for a human being. That is why, while interpreting Article 21 of the Constitution, the Supreme Court has said that right to reputation is also a fundamental right, and Article 21 encompasses that right. It is, and in that context, they quoted Bhagavad Gita, which says, Sambhavitasya ka kirti maranadapi pitayati. That is, for a man with honor, ill fame is worse than death. Therefore, the question of arrest becomes important in that context. For a person who is respected in the society, if he is arrested even once and detained even for a day, that same will result in humiliation, it curtails his freedom, and it casts a scar forever in his life. Therefore, arrest of a person is a very serious matter, and you cannot curtail the liberty of a citizen. Now, if a private individual curtails your liberty, then the Indian Penal Code will come into play. If a person is kept in wrongful confinement by one person, he will be liable for wrongful confinement under the IPC. Even if it is not confinement, but merely you prevent him from proceeding in particular direction. If he is stopped and not allowed to go, then it will be offense of wrongful restraint. So, taking away of the liberty by a private individual is considered under the Indian Penal Code. That protection is there. But so far as the government is concerned, it becomes necessary to maintain peace and law and order. Where offences are committed, it becomes necessary to investigate the offence and bring the offender to book. It is in that context that the Criminal Procedure Code permits the police to arrest a person, detain him, and also, with the order of the court, remand him to custody. And then, if the person arrested is entitled to it, he will be entitled to bail. This is also a fundamental right of a citizen. Now, in the Criminal Procedure Code, there are 3 provisions dealing with this arrest and detention. Section 41, 41A, and Section 57. These are the provisions. Now, this section 41 and 41J was amended in 2009 and 2010 because it was found that there used to be unwarranted, unnecessary, indiscriminate arrests and detention. So because 41 has originally stood before amendment in 2009, authorized the police to arrest a person merely on suspicion that he has committed a cognizable offence and a non-bailable offence. But this power was thoroughly misused by the police, and the colonial attitude of the police never changed. as stated by the Supreme Court. Therefore, these provisions were amended, and law provided that if a person is suspected to have committed an offence, on that ground alone you can't arrest a person. If the offence which is alleged to have committed is one for which the punishment is 7 years or less, then you don't arrest him. Instead of sending notice under section 41A and call him and record his statement and then deal with the matter. Without arresting the person, a charge sheet can be filed. So they have two categories. One is sentence less than 7 years, another is above 7 years. Even above 7 years imprisonment, they say arrest is not mandatory. You have power to arrest, but it is only under certain circumstances. Power to arrest is one thing, but exercising that power to arrest is different. There is no law which requires that a person who has committed offence should always be arrested. There are at least not many, few cases where the police register a FIR, investigate the matter, find that there is case against him, file a charge sheet. And the court, on the basis of the charge sheet, summons him and tries him. Therefore, without a formality of arrest, there could be a criminal prosecution which the criminal court will deal. This is the position. So, section 41, 41A read together, the power to arrest has to be exercised with due care only under peculiar circumstances. Supposing the accused is required for investigation, absolutely necessary, then, or he is likely to tamper with the evidence, or he is likely to abscond and may not be available for trial. If to that extent there is satisfaction, it is not merely saying the police must record the reasons for their satisfaction before arresting. Otherwise, such an arrest will be illegal. And after, therefore, the law is you need not mandatorily arrest any person, even in a cognizable offence and non-bailable offence. You can proceed with the investigation and file a charge sheet. But if you arrest, the conditions mentioned in 41A must always be fulfilled. That is recording of reasons, etc. How it has become necessary to arrest him. And the second important point is, after arrest, only they can be in his custody, police can keep in his custody for not more than 24 hours. Section 57 of the CRPC mandates that as early as possible, but at any rate, not later than 24 hours, he should be produced before a magistrate. So the power of detention in police custody is only for 24 hours. Beyond that, they can't detain. And producing a person arrested within 24 hours is a constitutional guarantee. Article 22 itself says that a person, any person arrested, shall be produced before a magistrate. Once he is produced, thereafter, whether he should be detained or not comes within the power of the magistrate. Now, the police, if it is necessary for investigation, can seek police custody for maximum period of 14 days. Beyond that, it will always be judicial custody. And it is in the discretion of the magistrate. Police may ask for any length of time, but the magistrate must exercise his discretion and allow police custody for the shortest possible period for the purpose of investigation. In earlier times, the police custody used to be for 1 day or 2 days, and thereafter, depending on the progress, further custody of 1 or 2 days like that, it was given. But nowadays, sometimes even 10 days custody, even at the very first instance, is given. This is not proper. Even before that, when the accused is produced before the magistrate within 24 hours, the magistrate has a duty to see that arrest is justified in the case. That section 41 and 41A are properly complied with by the police at the time of arrest. If they find that the arrest was not necessary or has been effected without recording proper reasons in the case diary, the magistrate is not bound to give authority for detention at all. In fit cases, magistrate can even release him straight away on his own bond. And this is the fundamental principle. Unfortunately, this power of the magistrate, which is very important because any detention before 24 hours is at the instance of the magistrate. So he will be responsible for that detention. So he must take care to see that further detention is justified. But unfortunately, in most cases, what happens is the police produce him, ask for police custody for 7 days or 10 days, and it is routinely granted. And after 14 days, of course, he has no power. They send him to judicial custody. Now, the courts have repeatedly said that magistrates or judge who orders detention must examine the case in detail, and only if it is justified, there should be further detention. Now, the Supreme Court, having realized that all these safeguards were not being properly adhered to, in the year 2014, in the case of one Arnesh Kumar, the Supreme Court, it's a case reported in 2014, 8 SCC 273, Arnesh Kumar case. Here, pointing out all these anomalies, indiscriminate arrest, routinely arresting though it is unwanted, and then magistrates routinely granting remand and all that. These are criticized, and in this case, the Supreme Court laid down detailed guidelines of the procedure, both for the police as well as the magistrate who is ordering detention. But unfortunately, even now, in spite of these directions, recently the Supreme Court said, in spite of these directions, they are not followed. And in this case, Supreme Court even said, the police or magistrate who violate this law or the guidelines, there should be disciplinary proceedings against them, even against the magistrate. High Court should take action. That is the direction in this case. This is a very important case, but as I said, even now, it is not being fully followed. In fact, in earlier, there was, if in the case of Yogendra Kumar, in the year 1994, the Supreme Court specifically said in the case of arrest, there should not be indiscriminate arrest, but if on justifiable ground you arrest even then, so many safeguards. First, his close relatives or people related to him must be informed of the arrest, so that the relatives must know what has happened to him and take all steps. Second, he is entitled to legal assistance of his choice, and he must be told you are entitled to have the legal assistance. If these safeguards are not given, it will be a serious lapse. And in that particular case, they found that there was illegal detention of a lawyer for 5 days, and habeas corpus petition had been filed. Even at this stage, I can mention you one thing. If there is illegal detention by police or anybody else without showing arrest as required by law, the best thing that a citizen can do is to immediately file a habeas corpus petition before the High Court. And that under law and procedure is required to be dealt with immediately, because it is a case where the liberty of a citizen has been wrongfully curtailed and he is in wrongful confinement. In fact, in England, I am told that if there is a habeas corpus petition filed, the court suspends all the other work of the day and will take up this first, because it involves the liberty of a citizen. And in this Jogin Kumar's case also, the Supreme Court bench of 3 judges presided over by Justice M.N. Venkatachalaya, they have said that the quality of nation's civilization can be largely measured by the methods it uses to enforcement of criminal law. And they have laid down the guidelines for the said purpose. Notwithstanding these two decisions, the guidelines of the Supreme Court are in many cases breached and indiscriminate arrests are made. And second is the responsibility of the magistrates. They have a higher responsibility because any detention thereafter is under their order. They should not routinely give either police custody or even judicial custody. And the Avnish Kumar case, Supreme Court said the magistrate, when he permits detention further, he must clearly say so in the order, and the reasons for such a satisfaction must also be reflected in the order. And if there is any lapse on the part of the magistrate, then he will also be liable for disciplinary proceedings. These are the guidelines and safeguards which the law imposes. There is another thing. If there is a threat of arrest, whether party has a remedy. Olden times there was no remedy. After arrest you can apply for bail, but there was no provision for anticipatory bail. But later on, our criminal procedure code has amended that provision for anticipatory bail, where you reasonably apprehend you will be arrested. But in practice, this has not been very useful because many courts, they don't grant interim orders, and anticipatory bail applications are simply adjourned by weeks together. By the time the police come and arrest, the application becomes impetuous. Thus, the provision, and another problem is, the court wants you to satisfy that there is apprehension of arrest. Unless there is a FIR, you will not have that proof to show that I am likely to be arrested. In most of the cases, suddenly they come and arrest without disclosing that there was an earlier affair. Like this, there are practical difficulties for obtaining anticipatory bail. Therefore, it is more important that before arresting a person, the police take due care and magistrate also take due care. Only 10 days back, Chief Justice of India, Justice Ramana, lamented, and these were the headlines in all newspapers. He said, unjustified arrest and difficulty to get bail is the worst thing that we are seeing today. He lamented against it. He specifically said difficulty to get bail and unjustified and unwarranted arrest by the police. And there is another way. Even this police custody for 14 days, the police or the investigating agencies have got all methods to circumvent the law. See, in the case of Mr. Chidambaram and later from Karnataka, Mr. Shivakumar, what happens? The police register FIR and then 14 days police custody is over. At the end of it, the ED opens another case and they again start investigation another 14 days. Like that, the law that you should never be in police custody for more than 14 days is also violated. These are matters which the court should take care of. This is one of the infirmities in the whole system. Ultimately, what is required is police reform. We must have a police force which has got great credibility. It should not be as in the colonial time. But unfortunately, police reforms, in spite of so many directions of the Supreme Court and also certain measures by the government, in effect, there has not been a substantial change in the attitude of the police. The police must become friendly. But today, even for giving a complaint, a person is afraid to enter the police station for fear of harassment. This attitude should go. People should feel free that police force is there to help them, and therefore they could easily approach them for relief. This is the position so far as arrest. Now, next I will come. When the arrest is effected and you are detained, what is to be done? Bail is the important right which a citizen has got. In ordinary offences, magistrates have right to grant bail. But in offences where life imprisonment or death is the punishment, Section 437 prohibits magistrate from granting bail. It is only session judge who can grant bail, unless some 4 categories. Even magistrate can grant for a woman or a sick person or infirm person, except the rest should go to Sessions Court. And while granting bail, there is no specific law as such regarding the circumstances under which bail can be granted or can be refused. It is all in practice we find, though rulings have laid down certain guidelines where it should be granted or it should not be granted. In practice, it is just like they say, equity varies with the foot of the chancellor. It is his discretion. there are no, whatever guidelines are there, ultimately it depends on the personal views of the magistrates or the judges. I will deal with little later. Only on the 11th of this month, 10 days back, in a very important judgment, the Supreme Court has given so many guidelines regarding bail. All that which I have now said, they have repeated that in spite of all these guidelines, they are being not followed and all that they say. And then they have said, we recommend to the government that as in United Kingdom, we must have a Bail Act in India, which comprehensively deals with the subject of bail, when it could be granted, when it could be refused, and what conditions can be imposed. Even today, there are cases where even when bail is granted, unwanted conditions are placed. Today, Supreme Court today interfered with the bail order. They said grant of bail is correct, but putting the condition that the university should be closed and the particular accused, the entire office must be sealed. They said it is unheard of and directed that to be removed. And in Karnataka, while dealing with the bail application, so many irrelevant things are either stated and or irrelevant information is sought for. Now, the Supreme Court stayed all of them. They said, when it is a case of bail, concentrate on that. Don't go into anything else. So these are the informative and most important point which is accepted by everybody is, both in India and UK, is that refusal of bail should not be by way of punishment. An accused who is arrested, till he is convicted, he is presumed to be not guilty. There is presumption of innocence in favor of him. So, before conviction, you can't detain him, even for an hour or for a day, as a matter of punishment. Now, so many cases, when the bail application comes, the court feels, you see, ultimately after trial, he will be acquitted. So, why should he be released now? Let him be inside for a couple of months. This attitude, Supreme Court other day frowned upon. On this attitude, don't detain person as a measure of punishment. It should never be. But in many cases, bail is refused merely, they don't say in the order, merely that is what is there in the mind of the court. And in law, bail is the rule and jail is exception. But many of the judges, as on today, consider it reverse. Jail is the rule, bail is the exception. The result is, in today's newspaper and also 2 days back, they have given statistics on an all India basis. In India, as on today, out of the inmates of all the prisons in the country, 80% are under trial prisoners. They are inside jail without conviction. Still, trial is going on. Only 20% of the inmates are, after conviction, serving sentence. This is because of the failure of the judiciary to properly consider the applications for bail. And broadly it is accepted. Even UK Act says that. Here also the judgments say, though there is no rule or statutory provision, a bail can be refused only on few grounds. One, that he is likely to abscond. and not available for trial. Second, he will destroy evidence. If these are third, he is likely to go on committing the same offense again. All this will not apply to generally first-time offenders. Of course, routinely in every bail application, the state will say, if you release him on bail, he is likely to abscond. He is likely to tamper with the evidence. And now, for that he is likely to abscond, the state has coined a new phrase. He is a flight risk. Everyone is a flight risk. Even Mr. Chidambaram, former finance minister and former home minister, and more than that, one of the most leading senior advocates continuously practicing before the Supreme Court, they said he is a flight risk. According to me, it is only a confession of the authorities of their inefficiency. Can such a person fly out of India if he is involved in a criminal case without knowledge of the authorities?
Yeah.
Of course, those who have been able to go like that, they have already gone. But today, you can't say any important person is a flight risk. These are routine things stated, and the magistrate, while refusing bail, will repeat this. I am satisfied if he is released, he is likely to tamper with evidence, he is likely to abscond, and therefore bail is refused. As I have said last time when I spoke to you, the case of Mr. Chidambaram was there. It is during that period, Supreme Court also was very tough. In the case of Sri Chidambaram, while he had a benefit of anticipatory interim order, anticipatory bail was pending, there was interim order. 1 year and all, the High Court suddenly one day rejected the application. And a person like Chidambaram was unable to get listed as the SLP before Supreme Court for the next 3-4 days. Before which they, as you all know, the CBI officials jumped over the compound wall, arrested him. And then now anticipatory bail has become infructuous. The result was a person of his stature. I am not saying because he was a minister and all that, but the allegation is of such a nature as the ministry had done something long back, and he is a senior counsel daily appearing before Supreme Court. Nobody. He had to be in custody for 100 days before Supreme Court could grant bail. Of course, now situation has slightly changed. The attitude of the Supreme Court also slightly changed. Even in Chidambaram's case, later on, the Supreme Court adopted a liberal approach. I should only say, Ardham Goswami was very lucky. He was able to get bail within a short time, in a matter of days from Supreme Court. But all are not as lucky. The present ministers of Bombay State, both former Home Minister and another minister, Mr. Malik, they are still in custody. They have not been able to get bail for months together. This is the situation. All this is because there are no set guidelines, and to a large extent, it also depends on who is the judge dealing with bail. There are some who are very liberal, there are some who are very strict. This is the unfortunate situation so far as bail is concerned. Other day, even in a lecture, Justice Chandrachud, he has been a liberal judge. You have seen yesterday, in the case of Zubair, one court grants bail, immediately another FIR is registered. Then that court grants bail, third, fourth, fifth, this was adopted. So the Supreme Court, because it was a bench presided by some Justice Chandrachud, they said, not only in these FIRs, but also in any other FIR you are likely to register, he shall not be, he shall be granted bail. So the efficiency of the courts in granting bail and care taken in ordering remand will deter the police also from bail. Now please take the instance, let alone acquittal later. In the case of Shah Rukh Khan's son, what is his name? Shah Rukh
Arbaz.
Khan's son.
Aryan Khan. Aryan.
You see, yeah. Now, for how long he was in custody? For nothing. Admittedly, nothing was found in his possession. And yet, bail was vehemently refused. And High Court refused to interfere, refused to entertain also. They said you go to Sessions Court, there it refused. Then High Court, there also refused. Thereafter, ultimately, bail is granted after so many days or months. And after investigation, they found he was innocent. They did not file a charge sheet. They closed the case. Now, who will compensate for the loss of reputation, inconvenience caused not only to him, but the entire family members? The humiliation suffered. That's why I said in the beginning itself, when there is arrest and detention, your whole life, what reputation you have earned is lost in few minutes. Therefore, we must be very careful to see that the liberty of the citizen is not unnecessarily curtailed by indiscriminate arrest and detention. Then there is another reason given for refusal of bail or anticipatory bail, and that is we want custodial interrogation. This is usual. Even Supreme Court, unfortunately, some judges have even accepted that condition. Yes, custodial interrogation is required. Now, under Article 20, Sub-Article 3, no accused can be compelled to be a witness against himself. So, right of silence on the part of the accused is an accepted right. And if that is so, he can say, I will not answer any question. Now, very interesting. In many cases, they say, though we have called him and questioned him, he is not cooperating, therefore remand him to custody or arrest him, permit us to arrest. Now, if before arrest, while answering he was evasive, he is entitled to be evasive. Supposing an answer is incriminating, he need not incriminate himself. That is why he has a right. Now, by custodial interrogation, before arrest, if he was not willing to give statement, after arrest, how will he give? Unless it be, you say you can torture him and use third degree method and extract confession from him. Is that what law says? Can a judiciary permit that? Therefore, according to me, denial of bail or anticipatory bail on the ground of that he is required for custodial interrogation is violative of Article 23 of the Constitution. And this position was clarified by the Supreme Court in the case of Selvi versus State of Karnataka dealing with this brain mopping, etc. Supreme Court said, you can't compel. Without his consent, you can't ask him for all these tests. this is one of the reasons. Recently, Calcutta High Court said some of the judges of the district judiciary are very stingy in the matter of grant of bail. That is what they say, High Court. But even in High Court, there are some judges. This principle has not percolated. In many cases, bail is refused by High Court judges. And not only bail is refused, in some cases where the district judge genuinely grants bail, High Court, finding that grant of bail is bad, passes strictures on the judge. And one such stricture is sufficient for in the whole state for district judiciary to be careful. They will say, oh, if I grant bail, the High Court will blame me, therefore better I reject it. Let them go and reject it. I have written a detailed article how such a conduct of the High Court will affect the lower judiciary and prompts them to reject bail. It is not in the interest of justice. No. Different notes. I did it. I have generally dealt with the main matters. I'll take just 5 or 10 minutes more to point out some things which have happened during the last few days. I said the Supreme Court, that is Justice S.K. Kaul and M.M. Sundaresh, on the 11th of July gave the important judgment where they say this bail law reform must be there. You must enact a law on the lines of UK, and they also stressed on Article 21 and how they also said bail application should be disposed of within 2 weeks, and anticipatory bail application should be disposed of within 6 weeks. And all that, United Kingdom, they have referred to the law. Then there is an article where, after in detail stating how the magistrates act in remanding, this article, the heading is, we need a vigilant magistracy for all the ills regarding wrongful arrest and detention, and says magistrates can effectively protect citizens from being hounded by the state if they refuse to readily authorize detention in vexatious cases. Malicious prosecution and harassment using criminal law will dwindle if courts invoke their authority to punish police officers who initiate such proceedings or indulge in fabrication of evidence. When the process is itself in punishment, an eventual acquittal does little to compensate for the trauma caused. Ultimate acquittal is of no consequence because you have suffered enough by denial of bail and being given. On July 11th, Supreme Court strongly disapproved this practice and said that the situation has a vestige of colonial India and observed that a democracy should not resemble a police state. And in all the papers, the speech given by the Chief Justice of India, in one leading paper, the heading is hasty arrest near impossible bail show need for overall CJI. Not anybody but the head of the judiciary saying this. Courts, the division bench Justice Paul and another in the other day's judgment, they say courts tend to think that possibility of conviction being nearer to rarity, bail application will have to be decided distinctly, decided strictly contrary to legal principles. That this itself is a punishment. Therefore, don't grant bail. This is the attitude of the courts. This should not happen. Therefore, in conclusion, I say that the recent judgment of the Supreme Court recommending a bail act is welcome. I hope the government will take action to bring about such a enactment. And I also hope that all concerned will be informed of the need to follow all the guidelines which have been prescribed by the Supreme Court. And there is a great responsibility on the district courts and magistrates to grant bail in fit cases without being afraid of any action by the high courts. High courts also should not give an impression that wherever bail is granted, the man must undergo any trauma or punishment. Thank you very much.
Sir, I'd like to play. I would like to play Nitin Gadkari's statement, but before that, how is that midnight? See the differences between Arnab Goswami case and Zubair case. Arnab Goswami, as you rightly said, we have done the case, show that immediately, as the way he was picked up as if he's a big terrorist, and same happening with Zubair, till proved no one guilty. But Arnab Goswami's case, Supreme Court accepts, and he is on a he's enjoying his freedom. But see Zubair, so many cases, similar cases registered, and Supreme Court had to intervene after so many days. How do you look at this scenario of justice being, done in a different way in similar cases?
That's why I said in the beginning itself, it all depends upon the judge concerned. You see, at least Zubair was able to get relief immediately because the matter has come before Justice Chandrachud, and he immediately granted relief. Similarly, case of Arnab also has gone before the same judge who was generally liberal in the matter of grant of bail, because some judges take this very strictly. Personal liberty is a very important matter and therefore should not be curtailed. But you can't expect, after all, you see, there are 35 judges in the Supreme Court. You can't expect every judge to have the same attitude or the same line of reasoning to decide a case. Therefore, unlike in America, United States, all the 9 judges sit, and there is no question of difference of opinion. It is one court, but here it is not so. The pendency of cases are so many, they have to be. But what I say is, Zubair also should consider himself as lucky as Arnab because he got the relief, at least within few days. But what about Ryan and Chidambaram and D.K. Shivakumar and so many others? It all depends on the person. That is why I am welcoming the enactment, a definite enactment, which at least will say you shall not reject bail on these grounds. You shall take these considerations into consideration while granting bail. Of course, rulings are there, but there is difference between a guideline in a judgment and a statutory provision. Statutory provision will have greater sanctity.
But this
It
is,
is the position.
don't you think this is just nothing but making mockery? Because of judge's discretion only you'll get bail, or face value of an advocate you'll get bail. Is it not? As you rightly said, if 9 judges in America, they have similar opinion, how can you have different opinions on the same bail petition?
See, if on one set of facts only one view is possible, why should there be 4 hierarchy of courts? Why Kunti's court judgment is either accepted or reversed by a civil judge, and the order of civil judge is either accepted or rejected by the High Court, and High Court judgment is either accepted or reversed by the Supreme Court. And why Supreme Court itself, 7-judge bench reverses the view of the 5-judge bench earlier, and 13-judge bench reverses the view of 7-judge. These are things which you can't avoid, because judges can't act like one machine, computer. It went long back. Justice Hegde of the Supreme Court, case Hegde, in 69, Supreme Court has said, judges are not computers,
Yes.
which use. And I have also said so many times, law is not mathematics.
Yes.
In mathematics, you can say 2 plus 2 is 4. Nobody can say it is 5 or 3. But in law, on same set of facts, one judge may feel it's a case for conviction. Another judge may feel it's a case for acquittal. It is something which can't be avoided.
But this
This
is
is why we have so many hierarchies. And appeal only for that purpose. Otherwise, why should there be appeal if there could be only one view?
no, but at the same time, the normal common man, don't you think they don't have reach? They will suffer. It is not infringement of their fundamental right. For, as you rightly said, so many anomalies in the way judges interpret. But when you don't have wherewithal
You will
resources are not there. See, I can't go to Supreme Court if something happens because of the money with which I cannot hire a good advocate, nor I can go to Delhi. So for that matter, Supreme Court should be there in every region.
No, you are wrong. It is not as if Supreme Court alone is right. Even among magistrates, some grant bail, some are a bit strict. You can't expect all the magistrates of the same rank to act with mathematical precision. It is not a question of rank. It is not a question of rank. It is a question of judges of different rank will take different views, because it is human conduct. Can you expect all to have similar? That's why I say law is not mathematics. You can't expect mathematical accuracy in all cases. Even the Supreme Court of United States, though all sit together, why did the other day reverse the judgment?
Abortion.
Which stood the
Abortion.
test of time for 20 years, they reversed it, and abortion right is taken away.
But
from
that's
the
okay.
people.
That becomes a societal issue. But here, these anomalies, don't you think, are being exploited by the politicians and police, P square, to punish journalists or common man who speak against them? These anomalies, don't you think, are become a big?
See, a magistrate acts similarly whether he is a common man or a very rich person. The judges do not decide it on the basis of the status, whether it's a magistrate or a high court. They never go by the status of the person. They go by the facts of the case. On facts, it is always possible to take different views. X may take one view, Y may take another view. For instance, I will tell you, it is accepted by all. Among the judges, generally, there are few who are pro-landlord, who are pro-tenant, who are pro-government, pro-citizen, pro-establishment, and like that, pro-labor and pro-management. In the matter of labor cases, it depends on the particular judge, and the Supreme Court also varies. There were judges like Justice D.A. Desai. He was supposed to be always in favor of labor. Of recent times, Justice Gopal Gowda. He was supposed to be always in favor of the labor because they are the oppressed class. One will have sympathy. But you can't expect everyone to do that way. After all, human beings cannot act like machines.
That is
That we must
accepted.
realize.
But at the same time, now law has become a lottery in the name of discretion for a common man.
In fact, when a case was being argued before Supreme Court, this question arose. The meaning of the word lottery or game,
Lottery, and law has become a lottery because of the discretion of the judges to grant bail, or because we should be lucky. We should be lucky to have a pro judge whose mind is for bail.
See, before the Supreme Court, when question was what is a lottery or what is a game of chance or game of skill, now the lawyer said, I can't define it, but I can give an instance. What happens in Supreme Court on Monday and Friday, where SLPs are heard and disposed of, it is a game of chance. That's what he said. When 100 SLPs are there, which will be admitted, which will be rejected, it is a game of chance. Like that.
But can we allow
These are
this?
inherent things.
No,
You-
these are because
see,
of
you can only
because you are such an experienced legal fraternity. Can we leave anything because in the name of in the name of workload are so many cases to be disposed? Can justice be denied?
not that. See, you can take it for granted. It is not something peculiar to our country. In every country, you can't say all the courts will give a uniform judgment,
Okay.
irrespective of the judge. You must be knowing United States appointment is made by the president. And they say how many judges of the 9 are belonging to Republican Party or having leanings towards Republican Party or Democrats. You can't avoid it. Because human nature is such. You can't expect all human beings to act equally or react in a particular manner. No. Different man will react differently. Therefore, this is something, thereby, to minimize the discrimination, this law is to be brought regarding bail.
Bail.
That is what Supreme Court has said. So that the area of discretion is reduced to the minimum.
That you mean to say
That's all.
Article
That's it.
41 amendment. Article 41 amendment, wherein, as you rightly stated, the bail discretion of the judges is restricted or minimized, so that you have a common laid down principles or norms for granting bail.
No. 41 doesn't do that. When they are arrest, when they can't arrest, they put some restriction on arrest. You shall not arrest unless these are followed. Not Constitution, Criminal Procedure Code. That part is only to arrest. Now, granting bail, not granting bail, it is judge-made decisions right from the beginning. When should be granted, not granted. 1950, Supreme Court itself starts from that day. And the leading case ultimately came when Justice Krishna Iyer
Yes.
was in the bench, he started a judgment. Whether bail or jet is the question in this case. He laid down so many norms. When you should grant, when you should not grant. And they are being followed. This is just like in a murder. In the case of murder, they said either life sentence or death sentence. Now, they said in rarest of rare cases, death sentence. No, what is rarest of rare cases? Each judge differs. Even today, there is no unanimity.
Right.
There are some judges who will find some ground to reduce it to life. But there are some judges who feel so long as death sentence is there, I feel because of the oath I have taken, I must confirm death sentence in this case. But some judges are not like that. They find a way out and see that man's life is saved because some are reluctant to take away life.
Right, and that is wonderful. So I only hope that Justice Krishna Iyer's laid down principles are already there for bails, but as you rightly recommend and as you rightly invite and as you rightly opine that the Chief Justice of Supreme Court expressing concern in regards to bail, there should be an equal law for bails to amend Criminal Procedure Code. Am I right, sir? In lines with United Kingdom.
A separate enactment. They have recommended a separate enactment, Bail Act, and in UK. Then they have also suggested.
Right.
And UK, we know what the provisions are. Similar provisions with the required modifications to suit our Indian conditions. You must bring a new law. That's what they have said.
New law should be brought in, and again we were reminded of Madhya Pradesh High Court's direction to magistrates. How is that if police produce someone in the midnight, magistrate doesn't listen to the one who has produced accused? Without listening, just on the name of police, he grants police custody or sends them to jail. Is this not making mockery of the personal liberty, sir? Infringement? When Madhya Pradesh High Court did pass, right from municipal magistrate, district magistrates, they need to act. Am I right, sir? They are at their discretion. Whatever police says, they should not blindly follow. They should allow the accused to open his mouth and speak.
Please read the judgment which I referred on 11th July. Justice Cole, he mentions all these. Many magistrates order remand in a mechanical and casual manner. And also that Arnesh Kumar, as I said, you please read the judgment. They use this very expression. Magistrates should not, in a routine and casual manner, direct permit detention. They must, if they find that the arrest was unwarranted, they should immediately release and should not order detention. And those magistrates who do it casually, disciplinary action should be taken against them. These are all the guidelines. But this is applicable to thousands of cases all over the country, whether a particular magistrate does it or not. Even there are thousands of magistrates in the country.
But
It all
see, even
depends on
we have
the-
quoted Article 22, reputation for even Shah Rukh Khan's son. They did not go and file anything because they should have filed something wherein that enactment, as you rightly said, Article 22, the reputation would have come into play. Those judges or magistrates who have ordered illegal detention, because Shah Rukh Khan's son is now found to be not guilty, and but his reputation being in jail and all that hangama which has taken place has put them into disrepute. But who is going to prosecute these magistrates or judges, sir? Who should prosecute them, and how should a common man approach this?
See, Aryan Khan, I only gave an example.
No, that
There are thousands of cases
thousands, yes.
where people have been in and they are acquitted. There are certain problems for which you can't have solution.
Right. And you mean to say, how can I approach if something goes wrong against me and my reputation is tarnished? How do I approach for disciplinary action or action as
You
per
have-
rule of law.
You have, you have every right to file a civil suit and claim damages from the officer who has done it, or also the government which has done it.
It is only a civil suit, not criminal
Only
procedure
thing
act.
is, very rarely it is done. There is always a provision for suit for malicious prosecution. You can also file a suit for malicious arrest, claim damages. But court will, there you have to prove that arrest was malicious.
Right.
But in due discharge of duties, even two police officers, one may feel it's a case for arrest, another may feel not a case for arrest. How can you? See, you are not, please don't expect human beings to be like machines.
Right. Human beings cannot be machines, but at the
We
same
have-
time, unlawful
We have-
detention.
We have attitudes.
Yeah.
We have got our own views. Your view is different from my view.
Right.
And there are certain things which are inevitable.
Yes. But at the same time, as you rightly said, human views may differ, but it should not infringe the personal liberty, the right, fundamental rights. As rightly quoted, there should be an uniformity in bails, and enactment should come so that at least due diligence is taken in provide relief or justice. And at the same time, there is a provision for malicious arrest or detention, and that can be filed in civil court. I am asking about even against the officer, judicial officer and the government who indulge in that, you can claim damages. And is there any criminal procedure act also, sir, along with civil procedure code in these malicious arrests and
No, in fact, that case of Joginder Singh, I said, 2004 SCC judgment of M.N. Venkatachalayya. In that case, they found that the man was in illegal custody, and they said habeas corpus petition has become infructuous because the man is now available, so dismiss the petition. They said no, we will not dismiss. We direct the district judge to hold an inquiry and find out whether this man was really in illegal custody. If so, who is responsible for that? And send a report to the Supreme Court, and we will take further action. If there was an illegal detention, they could even be prosecuted. The person who has illegally detained, even if it is a police officer or a private individual, he can be prosecuted because it amounts to wrongful confinement, illegal confinement.
so
There is
police,
provision.
the police, even judges and even the government can be prosecuted if it is proved that is it is illegal confinement or wrongful confinement. We did mention this
No,
Chennai, Tamil Nadu cases. Tamil Nadu case also there was a detention
Please,
police.
please, I'm sorry. Please, see, judges can't be prosecuted. Police can be prosecuted. A judge, if he is careless in ordering remand, disciplinary action can be taken against him. That is what the Supreme Court clearly says. Judges, they have got Protection Act. Because if a judge is being prosecuted for giving a wrong judgment,
I know.
nobody will agree to become a judge. He must have protection. So, no question of prosecuting a judge. Prosecuting only police officials who maliciously and illegally detain a person without showing arrest.
Because he is the investigating officer. The courts has to trust the officers. That is the procedure. Courts have to follow because courts cannot have its own officers. They have to. They have to, and at the same time, civil suit can be filed for the damages, particular that office and against the government. That can also be done. Fine. This is what it is. Now we only hope people have so much of faith in judiciary at last when they feel the government not coming to the rescue, bureaucracy not coming to the rescue, and the bureaucracy, police being part of it. When they are being harassed, the last resort for any common man will be the courts. And as he rightly pointed out, the courts, even judges are human beings. Don't forget, they are also human beings. they are prone to human emotions. Let us welcome wonderful guests who are trying to champion the cause of the personal liberty and freedom. And let us assume that all these judges will understand that infringement will definitely destroy their reputation. Their families' comforts are totally destroyed. Their happiness is gone. So we only hope this discretion will become a natural act wherein they will understand as to whether the arrest is genuine, legally legitimate or not before they remand, or even for the matter of later on even the trial too, because here the poorer of the poorest should get equijustice. That is the beauty of our constitution. Just because he cannot approach, the justice should not be denied to him. The Judicial Services Authority should come to the fore when all of a sudden journalists are lifted overnight as if they are terrorists, produced in the house of magistrate, and he doesn't listen to them. And even after that, after whether it is police custody or after the remand, when again is reproduced, they don't even bother to listen. Many would not have even the access to legal aspects. They cannot even hire an advocate. And for that reason, as rightly pointed out, 80% of those are still, they have not convicted. They are still in jails. This is a big issue. The government as well as the judiciary should act now. See that no one illegally is put behind for no fault of his, for no crime committed, because till proved guilty, you should not put anyone behind bars, or for that matter, arrest, detain and deny bail. This is what is for this show from B.V.ACHARYA ji. Once again, it's a very hot topic which has been going on across India. We could not play the Nitin Gadkari's, Before I wind up, with due permission of our honorable guest, I will just play this video, what he has said, at least from the ruling fraternity, before we wind up the show, because this is an apt one to be played for this. One second, sir, I'll just play this video and we'll say bye.
देखिए, प्रधानमंत्री जो बात कह रहे हैं वो लोकतंत्र के विरोध में है। इस देश में भ्रष्ट नेताओं के खिलाफ और सरकारों के खिलाफ आंदोलन करना लोकतंत्र में संवैधानिक अधिकार है, जनता का अधिकार है, विपक्ष का अधिकार है, काम करने वाले देश के अनेक नागरिकों का अधिकार है। और ये अधिकार कोई कांग्रेस पार्टी या प्रधानमंत्री जी ने हिंदुस्तान के लोगों को नहीं दिया है। ये अधिकार हमारे संविधान में है। फंडामेंटल राइट, मूलभूत अधिकार, फ्रीडम ऑफ स्पीच, और ये सब बातें होने के बाद में भी शांतिपूर्ण तरीके से लोगों ने आंदोलन नहीं करना चाहिए। ये बात ये बात प्रधानमंत्री जी किस आधार पर कह रहे हैं? क्या उनका कहना कानूनी है? क्या उनका कहना संविधान के दायरे में उचित है? मुझे लगता है इसका प्रधानमंत्री ने आत्मपरीक्षण करना चाहिए। एक बात जरूर है कि जो लोग एक समय 2G स्पेक्ट्रम में जीरो भ्रष्टाचार हुआ कहने वाले लोग थे, जो एक बार रामदेव बाबा को संत कहकर उनको 3-3 बार 4-4 बार मिलने के लिए गए, जिन लोगों ने अन्ना हजारे के साथ चर्चा की 10 बार, तब लोग अच्छे थे। अब भ्रष्टाचार हटाने की बात को छोड़कर जो लोग बोल रहे उन्हीं को टारगेट करके एक प्रकार से उनको समाप्त कैसा किया जाए। अगर आप हमारे खिलाफ बोलेंगे तो हम आपका आंदोलन कोई चलने नहीं देंगे। इस प्रकार की नीति है। एक तरफ सरकार जिस प्रकार से काम कर रही है और जिस प्रकार से प्रधानमंत्री ने वक्तव्य दिया है, ये पूरी तरह लोकतंत्र के विरोध में है। और हिंदुस्तान के जनता जो लोकतंत्र को अपना आत्मा मानती है, वह ऐसे बातों का कभी समर्थन नहीं कर सकती, क्योंकि इमरजेंसी में इन्हीं हिंदुस्तान की जनता ने लोकतंत्र के विरोध में जो कुछ हुआ उसका प्रतिकार करके उस समय के सरकार को सबक सिखाई थी। और निश्चित रूप से अगर इसी प्रकार से प्रधानमंत्री जी अगर देश चलाना चाहते हैं तो देश की जनता इसको कभी बर्दाश्त नहीं।
So I just wanted to play this little video to make people to understand it is people participatory constitutional democracy where freedom of speech or expression should be the fundamental aspect, and every government, or for that matter whether it is judiciary or anyone, should have a proper view of this expression. That is what we would like to say, because India is a truly people participatory constitutional democracy, and we are a republic having submitted constitution to ourselves. So every citizen is a constitutional authority, right from Delhi to Gully. They are all public servants. This has to be borne in mind, and for that reason this show will make you very clear what is rule of law, what is arrest, what is detention, and what is bail, and why bail reforms are a must, a fundamental must in this given situation. So thank you very, very much, sir. Shubha Ratri, sir. So take care. Do support DRTSPR channels in larger public interest. For all the Indians, we say Sukha Nidra, Shubha Ratri. And for the world over, good morning, good afternoon, and good evening. Once again, Namaskaram, sir. Good night to you.
Follow
More